This video presents the content on winding up of companies under Companies Act. The winding up topic includes meaning of winding up, need for winding up by company, winding up rule 2020, liquidator, meaning, role and responsibility of liquidator, dissolution of company. What is winding up? Winding up means officially closing a company. During this process, the company's assets are sold to pay off its debts. Once everything is settled, the company's name is removed from the official records. After winding up, the company ceases to exist legally. The difference between winding up, liquidation, and dissolution. Winding up is process of closing a company. Liquidation means the sale of a company's assets to settle its debts. Dissolution is the final stage, where the company is legally closed, and its name is removed from official records. Following are the situations where company need to wind up. 1. When business is not making enough money to survive. 2. When company has completed the purpose for which it was created. 3. When company's owners disagree and cannot work together anymore. 4. When company is unable to pay its debts. 5. It is ordered by the National Company Law Tribunal, NCLT, or another authority to wind up. Following are the winding up rules as per Companies Amendment Act 2020. 1. On a winding up order being made, the company liquidator shall forthwith take into his custody or under his control all the properties and effects, actionable claims and the books and papers of the company, and it shall be the duty of all persons having custody of any of the properties, books and papers, cash or any other assets of the company, to deliver possession thereof to the company liquidator. 2. Where the company, its promoters, its key managerial personnel or any other person required to cooperate with the liquidator does not so cooperate, the liquidator may make an application to the tribunal for an appropriate order. 3. The tribunal, on receiving an application under sub-rule 2, shall by an order, direct such promoters, key managerial personnel or other person, including contractual counterparty, supplier, service provider or auditor, a. to provide the information requested by the liquidator, and b. to comply with the instructions of the liquidator and to cooperate with him in collection of information and taking custody of the assets, properties and books of accounts. Who is liquidator? Liquidator is an individual or entity appointed to oversee the process of winding up a company, which includes selling its assets, settling debts, and distributing any remaining assets to shareholders. Essentially, they manage the dissolution of the company, ensuring all legal and financial obligations are met. Following are roles and responsibilities of liquidator. 1. Winding up process. The liquidator is responsible for the entire process of winding up a company, which can be initiated voluntarily by the company or through a court order, compulsory liquidation. 2. Asset management. A key role of the liquidator is to identify, secure, and sell the company's assets to generate funds. 3. Debt settlement. The liquidator's priority is to settle the company's debts to creditors, using the proceeds from asset sales. 4. Distribution to shareholders. After all debts are settled, any remaining assets are distributed to the company's shareholders according to their rights. 5. Investigation. In some cases, liquidators may also investigate the company's affairs, including potential misconduct by directors, to ensure fairness and transparency in the process. 6. Appointment. Liquidators can be appointed by the court, creditors, or the company's shareholders, depending on the circumstances of the liquidation. When a company gets dissolved, the dissolution puts an end to the existence of the company, and the registrar then strikes off company's name from the register of companies. The company is dissolved by an order of the tribunal. The tribunal shall make an order of dissolution in any of the following cases. Section 481. When the affairs of the company have been completely wound up. When the tribunal is of the opinion that the liquidator cannot proceed with the winding up of the company for want of funds and assets or for any other reason. When the tribunal is of the opinion that it is just and reasonable to dissolve the company. On the making of the order of dissolution, the company stands dissolved from the date of the order. Within 30 days of the order, the liquidator must forward a copy of the order to the registrar who shall record the same in his books. If the liquidator makes a default in forwarding a copy, he shall be punishable with fine up to 500 rupees * for every day during which the default continues. It will be interesting to know that the liquidator or any other interested person may also apply to the tribunal for an order declaring the dissolution to be void. However, such an application must be made to the tribunal within 2 years of the dissolution. On such application, the tribunal may pass an order declaring the dissolution to be void under Section 559. The effect of such an order is that it makes the dissolution void ab initio, i.e., ineffective from the very beginning, and the company revives as if it had never been dissolved. Consequently, all the consequences resulting from the dissolution are avoided. Within 30 days of the tribunal order, the person on whose application the order was made must file a copy of the order with the registrar of companies who shall register the same. If such person makes a default in filing the copy with the registrar, he shall be punishable with fine up to 500 rupees for every day during which the default continues under section 559, 2. Thank you for watching this video.